co-ownership remedies that we are going to look at in this narration applies to free co-ownership. Now, the use and control of the co-owned property is usually regulated by means of a mutual use agreement between the co-owners within the co-ownership agreement, and also by way of the common law entitlements and obligations of co-owners as discussed in the previous two narrations. However, co-ownership is regarded to be the mother of all conflicts or disagreements, and this is encapsulated in the maxim or principle communio est mater rexarum. What happens in practice is that parties cannot agree on the content of the co-ownership and or use agreement, so a detailed agreement to assist with regulating conflicts between co-owners then do not exist, or the co-owners ownership and or use agreement is not always complied with. And in these circumstances, it is essential that when the rules regulating co-ownership fails in maintaining harmonious relationships, that remedies are available to bring relief. The co-owners can approach the court for assistance and use the co-ownership remedies that are at their disposal and appropriate to rely on based on the facts or the circumstances faced by the co-owners. Now let us have a look at these remedies. It is important that you understand these remedies to the extent that you can discern when which remedy is the most appropriate to apply, and know and understand the requirements of each remedy, which includes the principles and case law that applies to each remedy. In other words, you need to know how to apply these remedies to factual scenarios. Now, the first remedy that we will be looking at is the damages and or division of profit remedy. The question that we will start off with is, when is this an appropriate remedy to institute? So this would be an appropriate remedy to institute where a co-owner exceeds the reasonable use of the thing, and in the instance when a reasonable use is exceeded, but profit is also made without sharing the profit with the other co-owners. On top of this, harm should have resulted from this unreasonable use. Also, note that the co-owners must want compensation for the damage caused by the reasonable use, or they must want to claim the profit that the other co-owner did not share with them while using the property unreasonably. In this regard, the circumstances must be as such that the plaintiffs, meaning the other co-owners bringing the damages action, can show, or they must be able to show, all the elements of a delict. And there are 5 elements that must be proven. The first element is conduct, the second element is unlawfulness, the third element is causation, the fourth element is harm, and the fifth element is fault. Now let's have a look at the first element, conduct. Now, conduct refers to conduct, in other words, an action or an omission where there was a duty of care or a duty to act and the defendant failed to act. Now, conduct or omission must be shown on the part of the co-owner that unreasonably used the co-owned property. In the context of co-ownership and unreasonable use, the conduct that the plaintiff co-owners would have to show is that the other co-owner used the property. So there was conduct on his part, he used the property. The second element is unlawfulness. So unlawfulness is the second element that must be shown. This element requires that the conduct must be contrary to the law. And the law in this regard can refer to legislation, common law obligations, or agreement or contract. Now, unreasonable use or making of profit while using unreasonably is the unlawful conduct that would ordinarily meet this requirement in the context of co-ownership. Since unreasonable use is contrary to the common law co-ownership obligation to use and enjoy the property proportionate to the undivided shares and not in a manner that is prejudicial to the other co-owners. Now, when can we then say that reasonable use has been exceeded, meaning that there is unreasonable use? So we've already answered this question, but I'm just going to briefly go through the manifestations of unreasonable use that we've looked at previously. So firstly, as already indicated, when the property is used for a purpose other than the agreed upon purpose, then that use would constitute unreasonable use. Please look at footnote 109 in the General Principles prescribed textbook and footnote 17 in the Silverberg and Skuman online prescribed textbook, where there are a number of examples given of this type of unreasonable use. So if you are struggling to understand what this means, what it means to say that the property is being used for a reason that the co-owners did not agree upon, go and have a look at this footnote, because in the footnote you'll find examples of this. So the second manifestation of unreasonable use is where the use exceeds the co-owner's permitted use by way of not being proportionate to his or her undivided share in the property. And then the third manifestation is where a co-owner unilaterally gave a third party use rights in the property without first obtaining permission from the other co-owners. And this is the classic Pretorius versus Neft example here, where in that case one of the co-owners basically imposed a new co-owner on in the co-ownership relationship without first consulting with the other co-owners, and also while still using its share of the property its proportionate share of the property. So effectively using the property, still maximizing its share, but then also allowing another co-owner to use the property, thereby then exceeding its proportionate use. The third element that must be shown to prove damages or to succeed with a claim of damages is harm or damage. In terms of this element, the plaintiff co-owners will have to show that they suffered harm or damage. This must be shown by proving that their use rights and their rights in the property has been damaged or suffered harm because of the unreasonable use of the defendant or the co-owner. Usually this coincides with damage that may have been caused to the co-owned property. Now, considerations that the court will take into account in this context to determine the extent of the damage are the income and the profit made from the use, if there was income or profit made, the damage caused to the property, if there are any damage caused directly to the property and thereby the rights of the other co-owners, as well as all the undivided shares to determine the proportion of the damages amount to be awarded to each co-owner. Causation is the fourth element that needs to be shown. Now, co-owners will have to be able to show that there is a link or a nexus between the conduct complained of and the harm suffered. In other words, it must be shown that the harm resulted from the conduct of the co-owner. The last element that the plaintiff co-owners must satisfy is the fault requirement or the fault element. There must be fault on the part of the person or entity that used the property unreasonably. Fault is shown by proving that the harm was caused intentionally or negligently. When determining intention, a subjective test is applied to establish, based on the circumstances, whether the defendant intentionally caused harm through his or her unreasonable use. However, if there is no intentional harm, it must be determined if the harm was perhaps caused negligently. To determine negligence, the reasonable person or the objective test is applied. It is asked whether a reasonable person in the position of the defendant would have foreseen that his unreasonable use would cause harm, and if a reasonable person would have taken steps to prevent the harm from ensuing. If these questions can be answered in the affirmative, fault would be established through negligence. So these are then the 5 elements of a delict that must be present before co-owner plaintiffs can succeed with a damages claim. Now, what can be claimed in terms of the damages remedy? A co-owner can claim damages for the harm caused by the unreasonable use and or division of profit where profit was made while the property was used in an unreasonable manner. I refer you to the Pretorius versus Water case. This is not a prescribed case, but you can find the case's full citation in the bibliography at the back of your prescribed textbook. If you read the case, you will see then there how the court went about thinking about rationalizing whether or not the co-owners could succeed with this claim for profit.